Hello, ladies and gentlemen, welcome to Coin Lady channel. Here's a splash page from the SEC versus Ripple cryptocurrency case, a person who would reverse write that. In my interpretation, the SEC is up against Ripple. An ex-SEC attorney has spoken out against Ripple, claiming that early XRP investors would not get any financial return. This, of course, is something that has been discussed many times before. What is mentioned here, though, is something I had never seen before. And in the end, two lawyers from the XRP community joined attorney Bill Morgan. I'll also fill you in on a few statements that attorney Jeremy Hogan made. But the point we want to make is that there is a time limit on claims that can be brought against you. After a certain amount of time has passed, it becomes impossible to obtain money. I'll find the right words for you to use. They mention disgorgement as well as a form of compensation that was roughly equivalent to money. However, because so much time has gone, the financial consequences are less severe. However, I must state up front that I do not come from a legal or financial background. Please do not take anything I say as professional advice. Moreover, you know that you shouldn't act on my advice to buy or sell anything. I'm just a fan who occasionally posts videos to YouTube discussing random crypto-related things for kicks. Now, we're ready to go. An ex-SEC lawyer claims there will be no financial recourse if Judge Tourism determines that XRP sales between 2012 and 2015 are securities. It was great to witness that happen. This is from a former SEC attorney, and it sounds like they have a positive opinion about Ripple in general. As the court date in the litigation between Ripple and the SEC draws near, calm has prevailed. Members of the crypto community and legal professionals have been debating the case's potential resolution. Mark, how do you pronounce his last name for Gel, a former SEC attorney, made the comment yesterday in a tweet. Faisal. I could also say it in another way, but I'm not going to bother. No, I won't be participating. Okay, let's get moving. Let's get going. Not at all, I'm taking this position. That's a name that sounds completely made up. However, I'll be choosing that option because I have no interest in trying the alternative. Then what did Gels do to chill out? If you're going to go through all of this, might as well have names that are easier to pronounce. Former SEC attorney Mark Fagel #nailed that tweeted yesterday that there will be no financial recovery. A member of the XRP community asked partner at Morrison Cohen, Jason Gottlieb, on the latest episode of the Unchained podcast if the early XRP sales between 2012 and 2015 are securities for Gel. According to Gottlieb's interview, the SEC has 5 years after the offering of unregistered securities to file charges against the Ethereum founders. Since Ethereum was created more than 5 years ago, it will be challenging for the SEC to take action against it. And so, you may reasonably conclude. However, what gives, when some of the topics the SEC has been discussing in relation to Ripple effectively date back to the beginning of time? So, tell me, why exactly do we need to wait 5 years? This is a more complex approach than I would have expected, but it was raised by that attorney Gottlieb, and he may be onto something. Someone in the XRP community going by the moniker of Strikeforce published that video and commented, "I'm questioning the statute of limitations take." Even if lawyer Gottlieb claims numerous asterisks, XRP didn't begin trading until 2012. Litigation was scheduled for 2020. That equates to a time frame of 8 years. A possible defense for Ripples. Why go to all this trouble and expense to try to catch a break in the SEC? That, however, is a reasonable point of inquiry. As best as I can tell, trade in XRP didn't begin until sometime in 2013, not 2012. In spite of this, Mark Fidel Johnson, a former attorney for the Securities and Exchange Commission, and another member of the XRP community responded to this user by saying that the SEC claims the company sold XRP as part of an unregistered securities offering until 2020. The statute of limitations does not apply, but any monetary recovery must occur within the previous 5 years. Now, everyone, I'm going to act the part of a lawyer on the internet. But I can't even pretend to be a lawyer. That's really interesting, I hadn't heard anything like it before. So XRP community member and lawyer Bill Morgan jumped into response, saying, "So if Judge Torres finds early sales of XRP from 2012 to 2015 are investment contracts but not sales after 2015, it's impossible to get your money back." And Mark Fidel, who used to work for the SEC, chimes in to say, "Correct. Non-monetary redress, such as injunctions and bars, may now be available to them thanks to a recent legal development. However, I'm unsure if that would be effective in the past as well. Since OTL users are not investors and merely move money internationally with XRP, Attorney Morgan argues that the existing sales of Ripple are not investment contracts. The SEC may be unable to secure a permanent injunction on further sales, and instead receive only limited monetary remedies for existing sales." Cool idea, but then lawyer Flagella chimes in to suggest that's just one way the court could rule on how to divide the infant. "If I had to make a guess, I'd say the court finds Ripple liable based on the evidence presented. That seems like a no-brainer, but the court has denied injunctive relief, presumably because it is uncertain whether further transactions of XRP constitute securities. Sure, look, I'll abide by the judge's decision in regards to any potential violations of the Ripple effect. When I consider all of the counterarguments, I usually end up shrugging my shoulders and saying, maybe she finds something that's not crazy to think. But ultimately, as I usually come back to the same notion, even if that happens, as long as she knows, and I think she does, the need of providing transparency for secondary market transactions so that we as XRP holders have a road forward. That's the main thing, anyway. So, I guess we'll see what happens here. But lawyer Hogan stepped in and wrote to SEC lawyer Mark about the gel formula, claiming that a provision that was attached to a defense funding bill, I suppose, specifically applied retrospectively to equitable relief. Disgorgement was also recognized as a kind of equitable remedies in the case Liu versus SEC. That means it amounted to a substantial amount. Okay. Then, Attorney Morgan retorts to Attorney Hogan, saying, "Wasn't that the case, though? That said that the discouragement needed to take into account or offset against the income earned for the impugned activity, the expenses, earning that income." Attorney Hogan seems to agree, saying, "Bill, looks like you are right, as usual, that it was the Luke case." And as for that back then, he explained why he knew some of this. "CISA, the library was attacked from the northeast." Solicitor Morgan responded, "I'm all over these cases," adding a smiley face. "In reality, I trusted the library's attorney's assessment of the situation." He even brought up the question of whether disgorgement is available in Section 5 cases and attached a screenshot from the library case for those who want to read along digitally. For the sake of this video, I don't think it's required. But if you insist on looking, it's right there. Then there was the one who asked, "So is this been a positive outcome for Ripple question, Mark?" In a letter to Attorney Morgan. This is what Morgan, the attorney, had to say. This comment thread is about disgorgement as a form of remedy. The gist of the conversation with the former SEC attorney is that the SEC might not get any disgorgement if Ripple is found liable. Only up to 2015 word investment contracts can be found if the judge only finds Ripple XRP sales. Since current XRP sales are to on-demand liquidity users who are not investors and do not expect profits from XRP, I also discussed the prospect that the SEC will not gain a permanent injunction on future XRP sales. So now I'll say this, if an injunction were issued prohibiting the sale of XRP, that would be a major blow to the Ripple community. In that case, Ripple would have to sever ties with the USA altogether, as continuing to do business there is an impossibility. In any region that includes the United States, you have effectively destroyed their on-demand liquidity product. That would be a nightmare scenario for Rippling that can't be allowed, and it wouldn't even work if it did. But if that were to happen, well, I think that'd be stupid as heck and they fight that and probably win, even if it takes them to the Supreme Court level. So, once more, if I'm understanding Attorney Morgan correctly, that doesn't seem to be what's plausible based on what, but who knows? Bad decisions are made occasionally. I have hope, but the outcome depends on the votes. Please don't think of me as a financial advisor. Nothing I say should influence your buying or selling decisions. Please like and subscribe my channel. See you later, bye.